So today we are talking about renounceable letters of allotment from public companies. When a company first comes to the JSE, they usually offer a certain number of shares to the public as part of their effort to raise capital. This is called an initial public offer. So if the company is very successful and the shares are reasonably priced, far more applications for these shares will be received by the company than they have shares available to sell. Investors then say that they have been oversubscribed. The result of this is that shares have been allotted by the directors on some basis. Usually, this means that applicants will only get a percentage of the shares that they applied for. For example, 100 shares for every 500 applied for. Then, once the shares have been allocated, the company pays whatever excess money was raised back to the unsuccessful applicant. With a rights issue, existing shareholders are allotted new shares in direct proportion to the existing holding. They then receive a letter which entitles them to take up those shares under certain conditions. Those letters, which are called renounceable null paid letters of allocation, those letters themselves have a value and are often traded on the JSE alongside the company shares for a few weeks until the take-up date. This is a letter sent to the prospective subscriber, that is, the existing holders of shares in the company, in respect of which the offer is made, saying that a number of new shares have been allotted to them in proportion to the existing holding free of payment, which is commonly called a bonus or scrip issue, or inviting the shareholder to subscribe by paying for some or all of the new shares provisionally allotted to them in proportion to the existing holding. The offer gives a shareholder a right but not an obligation to subscribe for additional shares. In this situation, the shareholder may pay for the shares in full, but the shares will not be issued until sometime later when the offer to subscribe is closed. The letter is commonly known as a provisional allotment letter, as the allotment of shares remains provisional until the shareholder has accepted the offer and paid for the new shares. Now, if a shareholder decides not to take up the offer by the closing date, the allotment letter will then lapse. A public company will usually issue a renounceable letter of allotment to its existing shareholders, allowing them to subscribe for further shares. Now, while the renounceable letter of allotment remains provisional until such time that the shareholder has accepted the offer and paid for the new shares, the letter has some value, as it provides the shareholder with the rights to acquire new shares at below the current market price, or alternatively renounce that is sell the rights to subscribe for the shares to a third party. Similarly, if a shareholder decides not to take up the offer at the end of the renunciation period, the allotment letter will lapse. Now, how do you draft an allotment letter? It must be written like an official letter. It must be duly dated, stamped and signed by the authorized person. It must also include the number of shares allotted and the amount payable on the allotment. You also need to make sure to write it grammatically correct. Now, this letter should include the due date and the placement of allotment money. Allotment money payment. It should also contain the interest that will be charged on the allotment money receiving after the due date. It should include the consequences of non-payment of the allotment money. Furthermore, it must include the reference number of the share application and also the applied number of the shares. You also need to update the register of members and register of allotments. This is very good practice to update your register of members promptly, as this is the primary evidence of who owns shares in the company. Someone effectively becomes a shareholder when their name is entered into the register of members. However, in South African law, the deadline for updating the register of members is 2 months following the board approving an allotment. At the same time, the company should also update the register of allotments with details of each separate allotment of shares. Even if someone has already been issued shares in the company, you will need to add a new line into the register of allotments to reflect the new shares that you have issued to them. Now, to issue a share certificate to those who have been allotted shares, companies generally need to issue such a share certificate in respect of shares allotted, and by and large, it's something that shareholders will expect the company to do. An application for shares becomes binding on a shareholder when company notifies the shareholder that it accepts the application as far as the requirements of the Companies Act apply. The share certificate should be issued within 2 months of the share allotment. Most companies will, however, want to issue share certificates a lot earlier than that. This is because an application for shares only becomes binding on a new shareholder when the company notifies him that it accepts the application. Until the time, it is entirely possible for the potential shareholder to withdraw the application, a situation that the company will obviously want to avoid. Now, you need to show the new shares issued within the company's accounts. So this means you need to liaise with your accountant to ensure that the new share allotments are correctly reflected in the company's accounts for a certain period. When the company issues new shares, it increases the level of shareholders' funds shown in the balance sheet within the balance sheet itself, that there is different treatment given to the total amounts raised in respect of the nominal value of shares and share premiums. Now, if you've ever received an allotment letter or letter of allotment, now you know what that means and what it entails. So if you enjoyed this video, give it a thumbs up, subscribe to our YouTube channel, and stay tuned for more videos like this.